barrister at 39 Essex Chambers. So welcome to this session on what I think is an absolutely fascinating and really tricky scenario involving hoarded homes, issues relating to legal frameworks, including the Mental Capacity Act, potentially, and when perhaps we might need to think about going to some form of court, whether that's, for example, a magistrate's court in terms of environmental health law, or the Court of Protection. So I think we've got till about 12:30, and I'm really keen to use the morning as an opportunity to discuss, as I say, what is quite a tricky area of law. And I'm sure all of you will have had some sort of experience with hoarded homes and the challenges and difficulties and struggles actually that people have in that sort of environment. So please do feel free. Please do ask me anything as we go. All right. Don't leave your questions to the end. Just stick your hand up in the midst of something and ask me questions. All right. Because the last thing I want to do is just talk at a screen for the next 3 hours, although we will have a break. All right. So in terms of the materials for the session, I've just posted a link in the chat which contains everything you need. All right. So I'll just sort of give you a bit of a preview as to what you'll find there. And these materials will be available well beyond today. All right. So don't feel under any massive pressure of time to grab everything today. But in essence, you can get all the slides and some of the themes that are coming from Safeguarding Adult Reviews in relation to hoarding. There's a bit of discussion in relation to the complexity of capacity assessments. One thing that's often overlooked in a capacity assessment is that being able to make decisions means being able to not use or weigh, but use and weigh information, which I'll talk about. And then there's a bit of a quiz and some guidance notes on the Court of Protection, etc. All right. So if you go into the beginning of the online course, these are where you can. This is where you can download the slides. There's also quite a provocative book that's fascinating, actually. It's called Vile Bodies, and it's all to do with scenarios involving neglect or self-neglect, because I do think there's a difference, as well as hoarding and everything else. So I'd well recommend that as a worthy read. And then, as I say, you've got other bits and bats. I've put some videos in the online course as well that you can watch. All right. So that's where all the material is contained. And we'll all have had different sorts of experiences, I imagine, involving people who hoard stuff. The sort of angle that I tend to come at it from in terms of my work tends to be, I suppose, at the more severe end, when public bodies, other organizations have done their best to try and support someone at home, but the risks are so high. There might be issues around engagement where it's felt that there really is no other option now other than to go to court. And I focus mainly on the Court of Protection side of things, where obviously the person's ability to make their own decisions is our first issue, because if they can decide, then there's nothing the Court of Protection can do. And if they can't make that decision because of, for example, hoarding disorder, then we're in the realms of best interests and seeing what the court can do to try and support the person who is typically struggling. I also did the first case on hoarding in the Court of Protection. We've got two main cases that I'll talk about later. The one I did was called ACGC. I really wanted to call it ACDC, but it just didn't fit the initials. And then there's another case called a local authority in X, which I didn't do. So there are two main cases that I'll talk about later on. But what I want to do today really is to go through um, all of the sort of different elements of law that you may well encounter when you are dealing with these sorts of scenarios. So I'm going to start off by looking at the definition of what's called hoarding disorder, because it is a condition that's recognized in its own right. It has been recognized in its own right for the last 13 years or so, as opposed to being part of obsessive compulsive disorder. So it is a thing now, and it does have a definition. So we'll start with that, and then I'll talk about the multi-agency dimension required, because typically there's no one service or one kind of intervention that's going to make a real difference. Because of the complexities of what we're talking about, usually we always need a number of different organizations and agencies involved. So I'll talk about the other legal frameworks that are out there that might be relevant in a hoarding scenario, depending on what the issues are. Thirdly, I then want to get deep into the Care Act, for a number of reasons, really. One, because of the concept of dignity that is part of well-being that we're under a duty to promote. And I think sometimes you have scenarios where the person's dignity is at stake. So I want to talk a bit about that, and also because I'm a bit concerned that often eligible needs are not being identified in the context of hoarded homes. And obviously, eligible needs has quite significant legal implications in terms of local authority duties. So I'll talk a bit about the Care Act, and then I'm going to spend a bit of time on the Mental Capacity Act. So looking carefully at issues relating to capacity. What decision are we talking about? The test for capacity and the 5 abilities required to make decisions. Often people think there are 4, but there are actually 5 abilities. And the 5th one is often the key one in hoarding scenarios. And then I'll finish looking beyond the Mental Capacity Act, because we also have this other thing called the inherent jurisdiction of the High Court. And sometimes we might need to think about that, particularly if the cause of the person's inability is not necessarily hoarding disorder, but perhaps it might be an external cause. So perhaps they're under the undue influence of someone that is then causing real concerns. All right, so that's the sort of basic structure. But as I say, please do mute, but unmute and raise your hand if you've got any questions as we go. So, what are we talking about? Because there is a world of difference between collecting stuff on the one hand, hoarding stuff, which is not too risky on the other hand, and then hoarding disorder, which is significant. So, hoarding disorder is something that, as I mentioned earlier, has been recognized, certainly within psychiatry, psychology, for many years. So psychiatrists tend to use one of 2 what's called diagnostic manuals. These don't define a mental disorder for the purposes of English law. These manuals are designed to help with identifying symptoms and help with research within psychiatry. So in America, they use the Diagnostic and Statistical Manual version 5, the DSM-5, which you can see at the top there, contains so-called diagnostic criteria for hoarding disorder. In England and Wales, some psychiatrists use DSM-5, but ordinarily they look towards what's called the International Classification of Diseases, ICD, version 11. So this is the one that's perhaps more relevant, certainly within psychiatry. And again, the key point is that hoarding disorder is recognized there as a condition in and of itself, and it sets out various sort of elements or what's referred to as diagnostic requirements. Okay, now both of those manuals essentially highlight 4 key features of hoarding disorder. And so this is the important bit. What is hoarding disorder? So we're talking about a persistent difficulty in discarding or parting with possessions, regardless of their actual value, due to both a perceived need to save the items and distress at the thought of discarding them. Okay, so someone who's experiencing persistent difficulty due to both a need to save the stuff and distress at the thought of discarding them. Secondly, so you need all of these sort of features, if you like, before we talk about hoarding disorder. The second is that the person is amassing items so much that it's compromising the use or safety of living spaces. Okay, now many people amass items, but not to the extent that it's actually compromising the safe use of the living room, the kitchen, the bedroom, the bathroom. Okay, so we're talking about a certain level of hoarding, which is of a degree that's compromising the use or safety of those living spaces. We're not interested in the box room. If you're worried, if your box room is full to the ceiling, well, that's not a living space, right? That's like a cupboard area. We're not interested in that. It's the living spaces of the property that we're focusing on. And the third requirement, if you like, for this is that it's causing significant distress or significant impairment in social, occupational, or other important areas of the person's functioning. And finally, it's not better attributable or explained by some other condition. Okay, so when I'm talking about hoarding disorder, I'm talking about situations which are of a
So
of
I
that.
need to tell all of you who we are getting for our senior. Are we from?
Just
Yeah.
going to mute. Ah, we're talking about someone who is experiencing that level of distress, hoarded items, etc. Okay. And so when you think about it, because this is sometimes a phrase we see on the ground, which is completely inappropriate, by definition, this is not a lifestyle choice, right? Someone with hoarding disorder doesn't deliberately choose to live a lifestyle like this because they have persistent difficulty. It's causing significant distress or significant impairment. Never really should we describe someone with hoarding disorder as exercising some kind of lifestyle choice. Okay, it's just completely inappropriate because by definition, it isn't. And it's actually something that is very under recognized. All right, despite the severity and chronic nature of hoarding disorder, it's often unrecognized, even though it's thought that there are somewhere between 1 and 2% of the population in this country that might well have hoarding disorder. And there's been lots of research done on this, if you want to read more about it. So this big study, this meta-analysis in 2021, found that almost a quarter of people with hoarding disorder had attempted to take their own life at some point. So for many people, there's a risk of suicidal ideation, no doubt caused by the distress that they're experiencing. It's also a pretty common cause of house fires or deaths. And what I find really interesting is that there are certain themes or certain threads, if you like, that researchers have identified in relation to those with hoarded properties. So 80% of those that have hoarding disorder have described how their sort of their symptoms or behavior began in childhood. Could we make sure we're muted, please? So 80% reported symptoms before they reached adulthood. So that might be, so at the moment, you might have someone who was born after the Second World War, for example, who is now in their 70s and as a child experienced, a significant degree of struggle, and rationing and so on. In other scenarios, in childhood, one of their parents may have also had hoarding disorder, which has then influenced them. So it is quite common for this to sort of begin in childhood in some way. The other interesting feature is that people with hoarding disorder don't tend to seek help. All right. They are often, living their life and don't even come to the attention of services until the age of 50 on average. And obviously, by then, if this actually did begin in childhood and now the average age of coming to our attention is 50, then you've got the best part of 30 years during which they've been struggling with this. So their struggles are already pretty ingrained and well established, which is why, for example, if we talk about treatment, this is a very difficult condition to actually treat because it is so ingrained in their psychology. People with hoarding disorder often, there's a wide range of educational achievement. So you could have a professor of something or other who also struggles with hoarding disorder. Often people are incredibly intelligent, often able to make all decisions in life, but may struggle with this particular one. Low marriage rate. For those that do marry, high divorce rate. They tend to live by themselves. As I mentioned, family history of hoarding is common. And also, importantly, there is often related things that they may well be struggling with. So they may well experience depression, anxiety, social isolation, and loneliness. Okay, so that's the sort of definition, if you like, of hoarding disorder, those 4 features, all of which need to be present. And it's not a lifestyle choice by definition. And for those of you that have supported people in this scenario, it'd be interesting to know if you've seen similar sort of trends in terms of those common themes. So how is it identified? There's a very good video on Vimeo about hoarding disorder. I've put a link in the slides. So when you download the slides, I'd encourage you to have a watch of that. In practice, we tend to use a combination of things, really. So there is what's called the clutter image rating scale. There are also, if the person's willing to sort of engage with this, there are also some self-reporting tools, if you like, where people are asked a whole series of questions. Again, you can probably Google it to find it. The Saving Inventory Revised tool, it's called, where, as you can see, people are asked things like how much of the living area in your home is cluttered with possessions? And then it's referring to the living sort of areas. Zero is none, almost all or complete is a 4. So there's a whole series of questions that someone can answer, the outcome of which, again, will give you some indication of the degree of what they're experiencing. Okay, so those are the two main sort of tools, if you like, people use. So this just expands upon the clutter image rating scale. Compare that with your own kitchen. All right, where are you? Because of my wife, it's always a 1 in our house, but if it was just me, I'd probably be closer to a 2 or a 3. Essentially, anything above 4, so 4 and above, it is usually where we start to get concerned. And I suppose the sorts of cases I deal with in the Court of Protection tend to be at the bottom range, so 7 to 9. Those are the cases I'm dealing with. I've got a case at the moment where it's two brothers in their 70s, and one of them has hoarding disorder. The other one is struggling to cope with his brother, and the social worker probably totally inappropriately described him as like a reverse Womble, like the Wombles of Wimbledon, in the sense that he would go out into the community, get everything he could find, but rather than disposing of it like the Wombles in reverse, he would bring it back into the house. And over the years, the stuff, and it was loads of, concrete, papers, litter, anything he could find, really. It had reached up to about a meter short of the ceiling. So it was a sort of level 9 hoarding case, with massively significant risks. So much so, actually, that when the social worker went round to knock on the door, it would take the brothers the best part of an hour and a half to answer the door as they tried to meander and climb through the stuff. Okay, so that's the kitchen. This is an example of the image rating scale for a bedroom. And again, anything that's 4 and above tends to be of concern. And then this is an example of the living room. Again, 4 or above tends to be of concern. Like if you've got someone that's sort of 1 to 3, then they probably wouldn't even have eligible care needs, if we're just focusing on the Care Act. But 4 and above, they may well do. So that gives you a sense of degree. And then obviously there's quite a debate, I suspect, out there as, to what extent should hoarding be seen as a sort of diagnosis? To what extent should this be kind of medicalized? And I'm not going to kind of get into that debate, other than to say, within psychiatry, it is recognized as a mental impairment or mental disorder. But treatment is not necessarily available. And from my experience, which is why we need such a multi-agency response, those that have needs arising from hoarding disorder tend to fall, or they're at risk of falling between the gaps of statutory services. The most common being between social care and mental health care. Okay. And that's why I want to spend a bit of time on the Care Act side of things. They also, like the sorts of issues and needs arising from hoarding and the risks that are at stake, also tend to involve a range of different statutory services. So it might not just be social care or social services and community mental health services. It could often be the fire service. It might be the environmental health service or regulatory services, whatever you call them within your particular local authority. So there's the issues often touch on a wide range or might be relevant to a wide range of services. Um, in some scenarios, it can be very tempting in terms of, if you've got a very high risk scenario where there's a risk to life, whether that's to the person or perhaps neighbours, thinking of sort of fire risks in particular, sometimes it can be very tempting as a sort of quick fix to just go in and blitz the place and just remove everything. There is various laws that I'll talk about in that regard, but from my experience, that's normally a bad idea. Um, it may well be a plaster and temporarily reduce risk, but it's never going to address the underlying cause of why the person is in this scenario. Typically, it will definitely cause significant distress to the person. And if there was any trust, because trust is critical in these scenarios, right? Establishing some kind of trusting relationship between the person and a professional, whether that's the social worker or someone else, or trust between them and a neighbor or a friend. Trust is critical. And so if you're looking at emptying the property, that's going to completely undermine and destroy any sense of trust that the person had previously. So it's not usually a very good idea to go straight in that way. And also, as I say, that plaster over the risks is likely to be ripped away anyway, because in due course, the person is likely to hoard more stuff in order to replace what's been taken. All right, so that's not normally a good idea. Um, Obviously, there are some scenarios where there really is absolutely no option other than that sort of intervention. But generally speaking, I certainly would see that as a very last resort rather than a first choice. Because from the cases I've had, what I've been sort of noticing is that quite often hoarding disorder sort of originates from some kind of social factor. So quite often there are issues with relationships. And when someone experiences a relationship detachment of some kind, which often is a sense of bereavement, right? Because quite often, by the time the person gets their 50s, they might experience some kind of loss of a parent, for example. So that relationship detachment then very much increases the person's possession attachment. Okay, I've often seen a very clear link there between the person being detached emotionally from, a loved one and then becoming very much attached emotionally in relation to the belongings and possessions and stuff that they're accumulating, right? It's often almost they have a sort of emotional relationship or attachment to the stuff that they're acquiring. That's their comfort blanket emotionally. Okay, so I think that's important because you always want to think about, zoom out from the stuff in the property and look at the person and their relationships, social network, etc. Because sometimes that's where we find the key to help them. If they are willing to engage, as I say, they don't often seek help. But if the person is willing to engage, and if we have services to offer, which I'll come back to, then potentially there are various things that mental health services might be able to help with. So some people have had some benefit from certain forms of medication, for example. Psychological services can be incredibly helpful if the person's willing to engage. So things like CBT, skills training. The Royal College of Psychologists has produced some excellent guidance on hoarding disorder, which goes through the sorts of psychological interventions that might be appropriate, which I would again commend to you. Just Google it, you'll find it. So there are potential kind of treatment options to at least assist. Right? These aren't like cures. You can't cure hoarding disorder, right? But in the same way as you can't cure autism. But there are certain services out there, if the person's willing and open to them, that might at least assist with the distress side of things and help them better understand perhaps the underlying reasons why they feel this intense emotional attachment to their belongings. It is chronic. It can be progressive as a condition. And so, as I say, contrary to some of these awful TV programs you see about hoarding, the aim is never really to um, reach a stage where they're living in, a pristine level 1 home, right? That's just usually totally unrealistic. Instead, our focus is very much on mitigating risk. So trying to assist the person to go through and deal with some of this stuff in a way that reduces the risk to a level that's manageable. All right. So you should be thinking about, positive risk taking, but also what is tolerable from a risk perspective. Okay. That's usually the aim of what we're trying to do. So, for example, it might be looking to reduce the stuff from a meter to the ceiling down to a meter high from the floor. It might be changing the candles that are being used close to newspaper, the fire risk, to battery operated candles that don't have the fire risk. Yep. So it's about thinking creatively and thinking about ways and means of ensuring the person is relatively safe and mitigating risk. And obviously that requires a lot of effective care and support planning. It takes a lot of time. All right, I've got a case in the Court of Protection at the moment. We've been in court for 2 years, right? These sorts of scenarios take a lot of time as we try to build up trust, making tiny steps forward to try and mitigate risk. And as I say, trust is the key. Trying to find someone in their life who they trust and involving that person in risk mitigation is incredibly helpful. All right. So that just gives you a quick sort of overview of what we are focusing on. You're very quiet. Are there any questions arising so far in relation to this concept of hoarding disorder? No, not even in the chat. All right. Fair play. I say, don't hold back, right? There's no such thing as a daft question. This is tricky stuff. Okay, so multi-agency is my sort of main buzzword of the morning. All right, I can't stress how important a multi-agency response is. And the reason that's important is because obviously different agencies have different legal duties and powers, and they also have different knowledge and expertise. Okay, and there is no one kind of legal tool to address these cases. You need buy-in and cooperation from other organizations. So just to give you a bit of a flavor for um, what's out there, this is my kind of toolkit. There's probably stuff that's not on this list that I could add to it, but this is essentially my toolkit for hoarded homes. So looking at 12 o'clock and then working round the right hand side. Often we might need to be thinking about housing law, um, particularly, for example, if there's a landlord-tenant relationship. Sometimes hoarded homes get to the state of amounting to what's called a statutory nuisance under the Environmental Protection Act. In which case that provides other potential routes for the local authority to go down, where you might go to the environmental health or regulatory department. We have public health law dating back to the 1930s that is all about filthy or verminous properties. If there are rats or mice, we might be looking at the Prevention of Damage by Pests Act of 1949. There's some town and country planning stuff, particularly where there is items or belongings that are visible to the public, where there might be a local amenity sort of issue. We have clean neighborhoods and environmental laws. At 6 o'clock, I've put that in brackets because usually it's not the right thing to use. But there is antisocial behavior legislation out there, which again might be relevant to hoarding. But the reason I think that's an inappropriate tool to use is because if you breach that law, then that can give rise to criminal responses. And I just feel it's totally inappropriate to criminalize hoarding disorder. So that's why that's in brackets. The Mental Health Act of 1983, again, I don't tend to go down that route. Normally, someone with hoarding disorder doesn't need to be in a hospital, right? And we've talked about the difficulties in terms of treatment. And if there isn't a really effective treatment, why would you admit them to hospital? So ordinarily, I've had exceptions to this, but ordinarily, we wouldn't tend to go down the Mental Health Act route. But if any of you are approved mental health professionals, there might be certain high risk, urgent, real emergency scenarios where we might need to enter and remove the person to a place of safety. Section 135 of the Mental Health Act, that's only for about 24 hours or so. It's a temporary intervention, but sometimes that might be worth considering. But as I say, it's usually not the case because the risks have been there for so long. It's not usually something that's so urgent and sudden now that we need to intervene under the Mental Health Act. So I'm going to be focusing on 7 o'clock onwards, really. So the human rights side of things, because there are a number of human rights that are very relevant, I think, in hoarded homes. So obviously the main one is Article 8 of the European Convention. Article 8 is the right to respect for your private life, your family life, your home, and your correspondence. So in particular, private life, home are important Article 8 issues. Now, Article 8 of the European Convention is what's called a qualified human right, which basically means that sometimes we do need to interfere with that human right. And we can do so as long as we've followed the law, whichever of these laws we're using, and provided what we're doing is necessary and proportionate to a legitimate aim, which is either the person, protecting the person's health or maybe protecting the life or health of others in the neighborhood. So Article 8 is very relevant. In very extreme cases, if we are looking at removing someone from their home, there's usually an issue relating to Article 5, the right to liberty. Are they going to be deprived of their liberty whilst they're, for example, temporarily in some other setting, whether that's a care home or whatever place it might be? So human rights are very much at stake in these cases. I'm going to talk about the Care Act, eligible needs, safeguarding, and then we'll spend quite a bit of time on the Mental Capacity Act, because again, I think that requires some careful thought. And again, I put this one in brackets because ordinarily there isn't a kind of external controlling influence over the person. It's usually the hoarding disorder that's causing the issues. But we've had the odd case where the High Court has got involved. All right. So picking up on Jules's comment in the chat, we're seeing multiple cases of intergenerational hoarding, where hoarding by the next generation is being missed or considered okay because it's not quite as bad as their parents, but not as bad because it hasn't been happening for the same length of time based on what you have described. Yeah, Jules. So as I say, it's a question of degree, really. Like my uncle, in law, um, he was, well, to some extent, he still is a plumber, been a plumber all his life. He's now in his early 70s. He's got 3 garages packed with old boilers and old pieces of things that he didn't want to throw away when he was doing his plumbing jobs. Um, Within his own home, he has quite a few things in various parts of the property. His mother died about 10 years ago, which may have made things worse, but the level of hoarding, the level of stuff that he's hoarding is nowhere near the level we would reach before saying he had hoarding disorder. Do you know what I mean? Because it's not yet compromising the safe use of the living spaces in his property. Most of it is being stored, um, and he wouldn't reach the sort of threshold, if you like. But if, for example, the siblings, in terms of the intergenerational point, if the siblings are hoarding to a degree that reaches the sort of threshold, sort of level 4 plus, then it's not really a question of timing, is it? There's no minimum time before hoarding disorder is recognized. It's more about the extent and degree and risk and safety, rather than length of time. And I imagine someone can hoard stuff very quickly. Law is a student and currently looking at hoarding and the differences between the pathways for homeowners versus social housing tenants. How have I come across this? Is it common for homeowners to remain largely hidden and appear more at crisis point? Yes, Laura, I think it is more common in that regard, because if you're in social housing and someone has hoarding disorder, then that's usually going to come to someone's attention very quickly, not least the landlords, usually from complaints by other tenants. So you often come across this issue more readily in social housing for that sort of reason. Whereas when you own your own home, um, you're far more sort of under the radar, struggling to deal with this yourself. And there's, I suppose, um, you don't come to the attention of others as readily. Any research examining the correlation between those who have hoarding disorder and those who are autistic? Asks Claire. I don't know, Claire. That's not something I have looked into. I will have a quick look over coffee, because I would not be surprised, if I can put it that way. Certainly, in one of the cases I've been involved with, the person was autistic and had hoarding disorder. So I would not be surprised. Um, So if anyone is aware of any research that might assist Claire, please feel free to stick links in the chat, okay? Because I imagine we've all got various helpful resources we've used that others will have no idea about. So please, can I encourage you all, if you've got anything useful, stick the links in the chat so that we can get a nice sort of rich body of resources. Because as I say, this is tricky. All right, so let me go through some of the other laws that are out there, okay? And if I start with housing, so the Housing Act deals with of 85 deals with secure tenancies. Nowadays, most people have assured or assured short hold tenancies. That's the Housing Act of 1988. And in some scenarios, I suppose particularly if it's quite early on, before it's reached the sort of level 4+ stage, it might well be that the risks and issues are best dealt with under the sort of landlord and tenant relationship. All right, particularly in the context, well, whether that's private housing or social housing. Because there is ordinarily some kind of term or clause in the tenancy that is relevant to these sorts of issues and risks. And sometimes, in terms of acting proportionately, again, it probably depends on the relationship between the tenant and landlord. But sometimes, certainly at the earlier stages, these issues are best dealt with under housing law. If that doesn't address the issue and the hoarding increases, you may get to a stage, and my 2-year case is exactly this, where the landlord has applied to court for a possession order to evict the person with hoarding disorder. And again, if that's the case, landlords need to tread very carefully here, because hoarding disorder can amount to a disability, so far as the Equality Act is concerned. If someone has a disability, then landlords are under a duty to make reasonable adjustments. And so that requires a bit of thought. And if they end up seeking a possession order, then they'll have to show to the judge that they've acted proportionately. So in my case, we've got 2 sets of legal proceedings. You've got the possession order and you've got the court of protection case. So the judge has sort of what's called stayed the possession order. They've sort of frozen that set of proceedings whilst we try to address the issues in the court of protection. Okay, so that's sometimes one option that needs to be considered. You also have the Housing Act of 2004. And I should say I'm no expert in these areas of law, right? I don't do housing, which is why you need someone who does, for example, within the local authority. But under the Housing Act, for Category 1 hazards, so serious risk, that triggers a duty on the local authority to act. There are enforcement options, including an improvement notice, prohibition order, hazard awareness notices, emergency remedial actions, and emergency protection orders. So again, sometimes in these cases, we're not even looking to the Mental Capacity Act and the Court of Protection, because we might be able to support and address the issues through other legal means. Okay, so that's some stuff on housing, particularly if the person is a tenant, although I don't think Housing Act 2004 only applies to tenants. I think that would apply to homeowners as well. You then have environmental protection stuff. So sometimes we are dealing with what the law would describe as a statutory nuisance. And I've given you the legal definition of it. So it's any premises or accumulation or deposit of stuff which has reached a stage where it's prejudicial to the person, to health, not just the person's health, but prejudicial to health, or amounting to a nuisance. For example, I've got a case at the moment involving a lady in her early 60s who essentially has never been known to services. The only service she is known to is the GP. So she's led an entirely independent life. She's now in her 60s. She has a walking frame. She's a home owner. She lives alone, and has only recently come to the attention of services because of the state of the outdoors of her property. The first thing the neighbors noticed, and again, there was a bereavement in her life. Her parents owned their own home. Um, they both died. She inherited their other property. So there are two properties now that she has, the one she lives in and what was her parents' home that she inherited. And what's interesting about her case is that her parents' home is still immaculate, right? She's paying for a gardener to maintain the garden. It's absolutely immaculate. But in her own home, the brambles outside are completely overgrown, right, which is peeving off the neighbors. Um, they're going out in, the brambles have grown into the path, the pavement. There's like a small hole that she squeezes through to get to her front door. So that's how it's come to the attention of the local authority because of these overgrown brambles, as well as um, the seeing of rats in the area. And she won't engage at all. Various phone calls have been made, many which she won't answer. When she does, she doesn't want any support from social services. But there was significant concern, and the social worker went round and took some photographs which clearly showed a deterioration in the outdoors of the property. And through the letterbox, you could see that the property was massively hoarded, sort of level 8 stuff, sometimes level 9. Now, again, I think she probably has many of those common themes that I talked about earlier. And so the question that I was asked to answer was, should we go to the Court of Protection? Now, in terms of her capacity to make the decision, all we have really are photographs, neighborhood complaints, and the GP. And the GP thinks she's perfectly able to make her own decisions, but the GP is not aware of the extent to which her property has been hoarded. So, in that sort of scenario, my view was, well, rather than going to the Court of Protection and trying to remove her and then get, everyone in to sort of blitz the place, because I thought that's probably the worst thing we can do, even if we can prove incapacity. The better option is to think more about environmental responses. So whether this amounts to a statutory nuisance, I think it would. And therefore, the local authority has options. It can issue what's called a Section 80 abatement notice, which is basically a warning that the person needs to do X, Y, and Z within a certain period of time, usually about 28 days. And we're not talking about emptying the property, but reducing the level or addressing the brambles. Do you know what I mean? So it's a sort of list of work to do um, within a certain period of time. And then that at least provides the person with an opportunity to address this themselves, which is less restrictive than, going down the more extreme routes. Um, and then there are consequences if the person breaches it. So if there is a breach of those abatement notices, the local authority under this 1990 legislation can what's called abate the nuisance, basically deal with the nuisance. And if that involves a cost, then that can be recharged to the person. And in the more extreme cases, local authorities can even go to the magistrates court, go to the justice of the peace to obtain a warrant to enter the property. Now, again, that might sound pretty coercive, but if you've got, a risk to life, then this might be ultimately less restrictive than removing the person from their home. Yeah. Um, and in urgent cases, again, there are similar sort of steps that can be taken, but just in a much shorter period of time. So 9 days notice can be given if the state of the property is so defective as to be prejudicial to health or amounting to a nuisance. So put simply, if you don't work in like environmental health law or environmental protection law, speak to someone who does, right? Because they'll know the ins and outs of this in detail, and will be able to give you some advice as to potential options. You then have the Public Health Act. So again, like this is all from the 1930s. So that's why some of this terminology perhaps wouldn't be used nowadays. But Section 83 of that Act requires the cleansing of premises if they are in a filthy or unwholesome condition as to be prejudicial to health or are verminous. And again, if that sort of threshold is reached, similar sort of response, really. So providing the person with like a notice, which essentially is a warning letter, you need to do X, Y, and Z within this period. And if they don't, then steps can be taken to deal with the issue and recharge reasonable expenses. Okay, so all these different laws are available in different sorts of circumstances, but the legal response is quite similar. So if we're talking about rats or mice, which in my lady's case we were, again, we're looking at a different bit of law here, but the approach is very similar. So requiring steps to be taken to deal with the rats or mice, and if you don't, local authority can and recharge you for the cost. Okay. And then you've got the town and country planning stuff. So this allows the local authority to require an owner to address land or property whose condition is adversely affecting the amenity of the neighborhood. So here we're focusing more on the outdoors, right? You can't use this for inside the property, but this might be relevant if we're talking about cleaning up front yards or gardens, which are visible to the public. There's then the clean neighborhood stuff. So litter abatement notices. Again, this is mainly for outdoor stuff. And I just mentioned it, although I wouldn't tend to use it at all, but there are antisocial behaviour stuff, so community protection notices, but that's not likely to be appropriate for hoarding. All right, so that gives you a flavour for how much other law is out there, because I think sometimes people kind of jump to the Mental Capacity Act for the answer, when actually, depending on what we're talking about, it might be less restrictive, less distressing to go down those alternative routes. But depending on what your role is, you might not have any idea about these other routes, in which case speak to those who do. All right. So any questions or comments? Deborah, in terms of safeguarding, there are now more individuals that are being referred to adult social care with hoarding disorder with extreme risk, but it's extremely difficult in gaining support from mental health services despite it being a mental disorder. Yeah. This is because the person won't accept their support. That's right, usually. But they don't want to accept our support either. But we still have a duty to safeguard under Section 42. Yeah. Any suggestions on how to address this? Assessing capacity is also an issue and who's responsible. Yeah. So yeah, you're describing there, Deborah, the gap that I mentioned earlier. Someone at risk of falling between social care and sort of community type mental health services. And I don't know whether I think you're right that even if it's a mental disorder, if the person's not likely to engage, and I think there is a bit of debate about what that engagement should look like, right? What sort of reasonable adjustments, for example, should services take to engage? I might not come to you, but would you come to me? Do you know what I mean? So I think there's an important issue about engagement in that regard, because from my experience, um, even if like getting through the door of CMHT is an absolute nightmare. But even if you manage that, you've got a social worker who's really supportive and you've got a GP as well. And even if you get through the door of CMHT, they'll then give you an appointment date. Person doesn't go. You might get another one, person doesn't go, and then it's described as non-engagement and they are discharged from CMHT. It's massively frustrating. So that's why I think recognizing this as a mental disorder, as a disability, and thinking about reasonable adjustments when it comes to organizing um, these sorts of appointments is incredibly important. All right. And I will be talking a lot about Section 42 in a bit. Okay. Any other questions or comments, folks, before we take a short break?
I just want to say I completely agree with what is it Deborah was saying, but also the lady who mentioned before about the private housing and landlord housing. We're getting so much of this to adult care at the moment, and that MDT working's really hard because if they own their own house, you've only really got the GP, and I'll be honest, 80% of the time they don't always attend the strats, so you're sat there by yourself. But also the other side of it is if you manage to get them to engage, which is a really good, you feel like you're giving yourself a pat on the back. But at the end of it, if there's, say, when you wanted to dispose of like trip runs and tips and skips, sorry, that's what I'm thinking of, or that the
Yeah.
property needs some renovation, what you find is a lot of these people in hoarding situations, even if they're on home, have no finances except for the value of the property. So then you come hitting barriers of how you're actually going to fund the deep clean, how you're going to fund the skip, how you're going to fund the renovations. And it's
Yeah.
just,
So,
I know there's no answer there. It's just a really hard.
well, it's not necessarily a solution, but there is an answer in the sense that there are two key points to remember, Gemma. So, first of all this law that I've just gone through on those two slides, apart from the sort of landlord and tenant bit, obviously, but all the other stuff, all the environmental stuff, pests stuff, all of that has nothing to do with whether you're a tenant or the owner. Do you know what I mean? So those laws are
Yeah,
available if you own your own home. So I suppose that's the first key thing. And then the second key thing, which we'll look at after coffee, is well, if we are talking about an eligible need, right? So I own my own property that I live in, but I have eligible needs under the Care Act, then of course we're looking to the local authority to meet those needs. So how will those needs be met? And if the person doesn't have any money, they fall below the sort of financial thresholds, then of course it's for the local authority to fund. Do you know what I mean? So
yeah,
we'll look at the Care Act
yeah.
side of things after coffee. But yeah, thanks very much, Gemma.
Yeah.
Um, And I'll talk about the Court of Protection. Sometimes we're looking at financial deputyship in the Court of Protection as well. Um, Environmental services in Wigan will support us if there are high risks when someone owns their own homes. Yeah, absolutely, Deborah, because as I say, all this environmental stuff has nothing to do with the sort of resident status, whether they're a landlord or an owner of the property. All that environmental and public kind of health stuff is more about, well, it can be obviously the person's health, but it's also about nuisances to the community as well. So, regardless of your status, whether you're a tenant or an owner of your own property, all that law is equally applicable. All right, so that's a good point to break for coffee, after which we will zone in on the Care Act. All right, so we'll take until 10 to 11. All right, folks, so about 13 minutes. See you then. Right, welcome back, folks. You ready? let's see, just so I know you're ready. I can't see it. I reckon you go on shopping and I'll tell on you. I can see about 8 of you. Rest of you are going to be in trouble.
They're still cleaning the house.
Yeah, it's like, shit, I got to get this below level 4.
Yeah.
Otherwise, Neil's on to me. Right. Okay, so we've covered what is hoarding disorder. One thing that's interesting that I want to come back to is the extent to which, for example, a social worker could form a view that someone has hoarding disorder without the involvement of a psychiatrist, for example. Okay, so I'm going to come back to that when we look at the Mental Capacity Act, and I'm also actually going to touch on that now because the issue is the same in relation to the CARE Act. So let's have a look at the CARE Act. Now, I'm worried. I hope this is an unfounded worry, but I am worried that in the context of hoarding disorder, eligible needs are not being recognised. All right. So let's have a look at the CARE Act in a bit of depth because it's an incredibly important piece of legislation. It obviously starts with the general duty on local authorities to promote individuals' well-being, and well-being means well-being so far as relating to any of the following, and there are lots of different aspects of well-being, and many of them, when you have a look, are very relevant to hoarding. So personal dignity, right? Concept of dignity. Sometimes indignity is at stake in the more extreme hoarding scenarios. Physical and mental health and emotional well-being. That's an aspect of the CARE Act as well. You know, mental health, not just an issue for community mental health services. This is an aspect of well-being for social services purposes. Protection from neglect, control over their day-to-day life. Again, that is sometimes at stake in an extreme hoarding case. Suitability of living accommodation. Well, that falls squarely within the hoarding context. So, you know, in a hoarding scenario, there are many aspects of well-being under the CARE Act that are very relevant. And often I think people talk about, you know, autonomy. And of course, that is critical, right? Promoting people's ability to make their own decisions in life is something that we should all be aspiring to, but it's not the only principle at stake, right? There's also this concept of dignity, which is recognized in law, both legislation, as you can see here, but also in case law. So sometimes in a hoarding context, there is a balance, right? That as the ombudsman said in this particular report, again, you can Google it if you want to have a look. That's the reference for it. The ombudsman said there is a balance to be struck between autonomy and dignity. Okay. So you asked about safeguarding. Section 42 of the CARE Act sets out the duty to inquire. So I'm summarizing it here, but it says local authorities must make or cause to be made whatever inquiries it thinks necessary to enable it to decide whether any action should be taken in the adult's case, and if so, what and by whom. So there are, I mentioned earlier how it's not uncommon for someone who's had to struggle with hoarding disorder for the best part of their lives to not seek help and to not come to the attention of the state, whether the state is the local authority or some other organ of the state. And one of the most common ways in which they do come to our attention is through a Section 42, so a safeguarding alert in response to which we may well have a duty to inquire and decide what we're going to do. The statutory guidance to the Care Act explicitly, this isn't new, this is like, what, over 10 years ago, explicitly included hoarding in the context of what it describes as self-neglect. So in this paragraph, it says self-neglect covers a wide range of behavior, neglecting to care for one's personal hygiene, health, or surroundings, and includes behavior such as hoarding. Okay. A decision on whether a response is required under safeguarding will depend on the adult's ability to protect themselves by controlling their own behavior. There may come a point when they're no longer able to do this without external support. So thinking that through, if you are supporting or working with someone with hoarding disorder, as per the definition I gave earlier, by definition, they are unable to control their behavior. Okay, when you go back to that definition and how I was talking about how this causes significant distress or significant impairment, this sort of fairly clearly falls within what's being discussed here, I think, under the statutory guidance to the Care Act. Now, in terms of buy-in, I was talking about the importance of a multi-agency response. Usually the Section 42 approach, the inquiry itself, can be very helpful because on our part, if we are the local authority, there's a duty to cooperate with relevant parties, whether that's, for example, the fire service, environmental health, whatever it might be. And from their part, again, I've given you the reference if you want to look this up in the statutory guidance. There are some paragraphs about the importance of those other organisations working with us to ensure that we are cooperating with each other and are able, therefore, to approach this in a sort of holistic, multi-agency fashion. Okay, now, one thing that's important to note is that safeguarding doesn't actually provide any legal authority to do anything. All right. Safeguarding and the Section 42 inquiry duty is just that. It provides a duty to inquire. It provides a critical process, if you like. You'll all have your own sort of policies in relation to safeguarding. So it's a critical way of establishing a process to consider what's happening. But in terms of intervention or, some form of response or having the legal authority to do something, that's not provided under the heading of safeguarding. So that's why you need to look for other bits of law as a legal framework. Okay, so the intervention might be lawful under the Environmental Protection Act, for example, or it might be lawful under the, Pests Act or Public Health Act or the Mental Capacity Act. Those are the sort of legal frameworks that we would rely upon in a safeguarding context to essentially provide legal authority to intervene. Okay. All too often, something has happened, and the question is, well, what law did you use? And the answer is given as safeguarding? Well, safeguarding doesn't give you the legal authority to intervene. It provides an important process of coordination, cooperation, escalation, etc., etc. The actual legal authority to intervene will come from one of those other tools that I mentioned. Now, I was saying that I'm worried that eligible needs are not being identified. And this is the basis, if you like, for my concern. I'm very conscious of the fact that there are widespread delays often in terms of character assessments, reviews, but the law is very clear. So it sets a very low benchmark or threshold when it comes to a care act assessment. So section 9 says where it appears, so it's an appearance of need that triggers the duty to assess, where it appears to a local authority that an adult may have needs for care and support, the local authority must assess. Okay, so it's the appearance of potential need for care and support that then legally obliges a local authority to conduct an assessment. Okay. Now, what if the person is not interested, right? What if they refuse an assessment? Well, I think section 11 is particularly important. So I want to have a look at this in some detail. Section 11 of the Care Act says where an adult refuses a needs assessment, the local authority is not required to carry it out. But, and it's a critical but, in lots of scenarios, whether that's self-neglect or hoarding, but it says the local authority must carry out a needs assessment, right? And when the law says must, that's big news, right? It's not a may. The local authority must carry out a needs assessment if either the person lacks capacity to refuse the assessment and we're satisfied the assessment is in their best interests, or, this is probably the critical bit, the adult is experiencing or at risk of abuse or neglect. Okay, so that's important. Section 11 is very important because if you've got someone, let's say, who owns their own home, based on information received, they appear to be in need of care and support, we must assess if they're experiencing or at risk of neglect. Okay. And that includes self-neglect, which includes hoarding. Yeah, see how that all links together? So obviously, if they're not willing to or not wanting to engage in the assessment, that makes the assessment quite tricky because you're having to try and form a view on their care and support needs based on the information you've got available. But simply refusing an assessment doesn't mean we don't have to assess. Okay. There's then a question as to whether they have eligible needs. And Section 18 provides the duty on local authorities to meet eligible needs. And I want to look at eligible needs in detail so that we're clear about how those are defined. If the person has eligible needs, then we're under a duty to meet need. And the other thing I think that's really important, I was talking about how critical it can be to have a trusted person. Even if that's not, a family member, neighbor, whoever, don't forget the Care Act advocacy side of things. So we have Care Act advocates in relation to the assessment of need and in relation to safeguarding inquiries, section 67, 68, respectively. Okay, so sometimes it's important to consider a Care Act advocate to support a person during this process, and they may ultimately become a trusted person. You never know. Okay, so we all have needs, but we don't all have eligible needs. And we need to know the difference between the two, okay? So, and eligible needs, sorry, that should say 2015, not 2014. Eligible needs are those which satisfy all three of those requirements. So the person's needs arise from or relate to a physical or mental impairment or illness. Right, I'm just pausing there. Hoarding disorder would count as a mental impairment. And if you look at the statutory guidance, I can't remember the exact paragraph. I think it's like paragraph 6.104 or somewhere around there. The guidance is very clear that this does not require a formal diagnosis. All right, so you don't need a formal diagnosis from a medic for the purposes of Care Act assessments or for mental capacity assessments, which I'll come on to later. All right. So they have a need arising from or relating to mental impairments, and as a result, they are unable to achieve 2 or more of the 10 outcomes. Now, as an absolute minimum, again, bearing in mind the definition of hoarding disorder, I reckon they would really struggle with number 5. Okay, because hoarding disorder is where you're amassing items that are compromising the use or safety of the living areas, right? So number 5, using your home safely, is going to be very relevant. And I suspect number 6 is going to be very relevant, maintaining a habitable home. All right, so at the very least, these 2 outcomes are going to be relevant to whether the person has eligible needs. There may well be others as well, right? There might also be issues, I don't know, relating to nutrition, hygiene, etc. But at the very least, I would have thought 5 and 6 are going to be ones that we would have to be focusing on. So they've got needs arising from hoarding disorder. As a result, they're unable to achieve 5 and 6. And the third issue is whether, as a consequence, there is or likely to be a significant impact on their well-being. Again, looking at the definition of hoarding disorder, on the face of it, it would fall within that, right? Because it's causing significant distress or significant impairment in some aspects of their day-to-day functioning. Okay, so when you look at the definition of hoarding disorder, and then you look at the definition of eligible needs under the Care Act, you can see a direct correlation. Now, I'm not saying in every single case they will have eligible needs, right? Because it all depends on the particular circumstances. But I suspect in many, maybe most hoarding cases, looking at that definition of an eligible need, they may well have one. Yeah, does that make sense? And in terms of whether the person is able to achieve outcome 5 and 6, again, that's defined in the law. So you're unable to make use of your home safely. You're unable to maintain a habitable home if A, B, C, or D applies. So you're unable to achieve it without assistance, or you are able, but doing so causes you significant distress or anxiety. Again, that's very relevant in a hoarding disorder scenario. Or you are able, without assistance, but doing so endangers or is likely to endanger your health or safety or others. Again, just pausing there, that's interesting, because endangering others, maybe neighbors, I don't know, but endangering others could give rise to an eligible need if those other criteria are met, or you are able, but it's taking significantly longer than would normally be expected. Okay, so when we talk about eligible needs under the Care Act, That's the definition of an eligible need. And that's critical because if the person has eligible needs, then there's a legal duty on the local authority to meet them. Okay. I don't think this would tend to arise in a case of hoarding disorder, because usually the person's needs are sort of consistent and sometimes chronic, actually. But in other scenarios, you might have situations where the person's needs are fluctuating. And the example there is in relation to alcohol. Essentially, if that is the case, you can look at the person's circumstances over a longer period of time. So that's probably not relevant in a hoarding case, because the needs will be consistent and probably long-standing. Okay, so that's an eligible need. So the thing to think about and reflect on is, are we picking up eligible needs in hoarding scenarios? Right? I suspect in some we are, but in many perhaps we're not. Now that might be because we're not even recognizing that it might be an eligible need, or we might think actually we need to do a character assessment, but the person won't speak to us, right? Which is why section 11 is important, because if they're at risk of experiencing neglect, which this could fall within, there is a duty to assess. And then the other challenge, I think, is, okay, well, even if we recognize that the person has eligible needs that we have a duty to meet, how are we going to do that? How are we going to meet eligible needs? What services have we got to meet the needs of those that are unable to make safe use of their home or maintain a habitable home? Now, what I'd like you to do is stick in the chat everything you've ever come across in terms of a service that might help in a hoarding case. All right. So go ahead, stick in the chat. What have we got in Greater Manchester by way of a service that a local authority might turn to meet someone's eligible needs? Environmental health, Handy Ladies. Please do attach a link, Caroline. Handy Ladies in Stockport, Age UK, hoarding specialists. Fabulous. Like, if you've got web links for this, that'd be even better, although we can Google it. Cleaning services, hoarders, helping hoarders, peer support. Absolutely, Jules. I've found that service incredibly helpful. GMFRS, says Lisa. Forgive me, Lisa, I don't know what that stands for, but I will Google it.
Greater Manchester Fire Rescue Service.
Greater Manchester Fire Service.
Rescue, yeah.
Fire Rescue Service. Okay, thank you very much. Jigsaw's Hoarding Service. Yeah. My 2-year-long case involves someone who is a tenant with Jigsaw, and they have someone in particular that is very good to support tenants that are struggling with hoarding. Red Cross, okay. Howard's Domestics, not heard of them, Karen, but do find the link. I can't believe it's not clutter. All right. Living with Hoarding, Belongings Support Group in Wigan. Super, keep them coming, because to be honest, the law's interesting, but it's this stuff that really matters. Do you know what I mean? It's about Link Care. A lady wants to move to them. Okay. Mind. Super. The Prevention Alliance. Great. Super. Thanks, Jules. Hoarders helping hoarders. Great. Any more? Any more? Oh, there's Tidy Homes, Tidy Minds, isn't there, in Manchester? Anyone come across that? Let me see if I can find the name.
Yes, I have, and I was trying to remember the name and I couldn't, so thank you. Yeah, they're really good.
I'm just trying to see if they've got a website. They've come up on Facebook on a Google search. I'm just trying to see if they've got an actual website. Maybe it's just on Facebook they refer to, but Tidy Homes, Tidy Minds. Brilliant. Thank you, Janine, for the the Salford Trafford safeguarding. Great. Healthy Stockport. Okay, another one I've come across, I think are fantastic, is Cloud's End. And they provide both support and training. So I'll stick them in the chat. And thank you, Catherine. So yeah, Cloud's End. I've even, like in court protection cases, I've even asked them to do an expert report in tricky hoarding cases. So I'm not on commission, but I've always found them incredibly helpful. Right, great. And if there's any more folks, stick them in the chat, because from my experience, you know, I do a lot of sort of Care Act hoarding kind of training, and they'll end up saying, look, these are often eligible needs. And then the question is, okay, well, how do we meet them, Neil? And that's where this list is incredibly important. All right. Because I fear nationally, we don't have enough specialist hoarding services. Do you know what I mean? So the longer this list is, the better. And if I were you, I don't know if you have access to the chat afterwards, but I think all of that is incredibly important. So thanks for sharing what you've come across. Is helpful. Did you mention Hoarding Disorders UK? Was that on the list? If not, again, that's a potential option. I'll just stick the link in the chat. Hoarding Disorders UK. Red Squirrel for people experiencing hoarding. Super. Thanks, Catherine. So there you've got some ideas. All right. And obviously, eligible needs is your kind of first key consideration. And then you have your financial assessments to think about. All right. Now, obviously, if they're living in their own home, we disregard the value of the property in the financial assessment. So that may well depend on the level of savings, the level of income, etc. Right. There's always a discretion anyway, even if, for example, the person has money but they're refusing to pay. There's always a discretion to provide these sorts of services. And I imagine some of these services might actually not charge. So for those that mentioned Hoarders Helping Hoarders support group, I imagine that that's a free service that's being provided, although do correct me if I'm wrong. But looking at their website, it looks like a free service again that obviously requires engagement. Yeah. Okay. Thanks, Jules. Okay, so that's Care Act eligible needs. Are there any questions arising from that? That's important when we get onto issues of capacity, you see, because I want us to think about if there are concerns in relation to capacity, what is the decision we're assessing the person's ability to make? Now, that might vary depending on the context, but to give you a flavour, if the person's been assessed as having eligible needs under the Care Act, and we are offering some form of service to meet those needs, the decision might be whether they have capacity regarding their care and support. Yeah, does that make sense? So it all kind of, these sorts of areas very much interrelate with each other. So let's move on to the issue of capacity and best interests. Okay, so I've emphasized how there's other legal stuff out there that might be more appropriate. But there's also, of course, the Mental Capacity Act as well. So we're all familiar, hopefully, with the principles. There's an assumption, a starting point of capacity with an ongoing obligation to promote capacity. So to build a pathway to capacity where there's a prospect of it. That's a judge from the case involving Warrington. And I think in some of these scenarios, rather than sort of jumping towards a determination of incapacity, in some cases, we can support people who hoard by taking practicable steps to make their own decisions. So the second principle of the Act is important. A person is not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken without success. So think about people who have a hoarded home where the thought of parting with or discarding stuff that they have this emotional attachment to is causing them significant distress and compromising the safe use of their living spaces. What practicable steps might we take to help them in this regard? Because you might have scenarios where the person recognizes why everyone is so concerned. Say, often those with hoarded homes can be incredibly intelligent, right? And they might have the ability to make all sorts of decisions in life. But the one that they might particularly struggle with is in relation to what's being hoarded. Okay, so, and they might also say, yeah, I can see this needs to be dealt with, but not today. Do you know what I mean? And then today becomes tomorrow, then it becomes next week, next month, next year. And in the meantime, there are all these risks at stake. So it's worth thinking about, what could be done to support them to make decisions to try to mitigate the risks that they face. So can the decision wait? Quite often when you get a Section 42 safeguarding inquiry, everyone is suddenly panicking. There's a risk to life. We don't want to end up in the coroner's court. We need to act now. Well, pausing there, how long has the person been living with this risk? Right? Because it's going to be pretty unusual for this risk to have suddenly happened yesterday. Do you know what I mean? In all likelihood, they will probably have been living in this scenario with these risks for quite some time. So it might well be, and from my experience, there usually is time to try other things. Okay. So, for example, education, visual aids, organizers, schedules, alarms, calendars, checklists. Someone mentioned earlier the potential, subject to research bearing this out, but the potential link between hoarding and autism. Sometimes structure, scheduling, setting small tasks, measuring off achievements, even if it's a tiny bit of the stuff that's been hoarded, that could be a massive achievement for someone. So this is where patience and trust and practicable steps is incredibly important. So thinking outside the box essentially, and that's where I think the likes of Hoarders Helping Hoarders can be really helpful, because I bet that support group have got loads of ideas, loads of wonderful ways in terms of engaging someone and supporting them to perhaps manage and address these risks with some help. Okay, so this second principle of the Mental Capacity Act, I think, is incredibly relevant in hoarded scenarios. Who else might we seek to involve? We talked earlier about how difficult it can sometimes be to get buy-in from community sort of mental health services. Well, what about speech and language? What about psychology? I've put there the document I was talking about earlier from the British Psychological Society. Again, that's well worth a read. It's really interesting to look at the psychological perspective when it comes to hoarding. If you want a psychiatric perspective, the other week I came across a fabulous episode on Spotify, although this is also available on other platforms. But it's from the Royal College of Psychiatrists, part of their CPD that they've made available. And it's all about hoarding. Let me see if I can share the link in the chat. As I say, if you don't have Spotify, this is available on other platforms. But if you just look for Royal College of Psychiatrists and hoarding, you will be able to find it. Really, really interesting perspectives on hoarding. So who else might we look to involve? As I say, finding a trusted person is critical. In one of the cases I had, he was attending a day service, and there was someone in particular at the day service that he trusted. And so it took a bit of, negotiation with the day service manager, but we were able to persuade the day service manager to release this person to come round to the home and to support the person with the hoarded belongings that had been obtained. This was the so-called reverse Womble case. I still think that's totally inappropriate. But anyway, I had another case where a social worker described the house as a Victorian slum. Again, we need to think about our terminology. Do you know what I mean? Often it's better to refer to hoarded homes, I would suggest. But we had someone from the day service as a trusted person who he was willing to engage with, and it required a lot of time, patience. I felt really sorry for this support worker. I think her back must have been broken as she was doing all this heavy lifting. But we made real progress because he trusted her. Okay, so that psychological perspective is incredibly important. And that's why, we don't want to call out the removal men unless they've got experience or understanding of hoarding, because this typically requires a combination of sort of physical intervention in terms of moving stuff that might be pretty heavy, but with that understanding of hoarding and sympathy and empathy to manage the emotional fallout. Because as I say, you're talking about someone who has an emotional attachment to the stuff. Right? Removing the stuff is almost like a divorce emotionally that they may be going through. Do you know what I mean? It's massive. Never underestimate the emotional fallout or support that they might need. So that's why, we're looking towards specialist hoarding services, really. All right. So that's all about trying to empower. What might we do to support the person to make their own decisions? It's also important to think about when an assessment of capacity is required. So I was saying that under the Care Act, the duty to assess is a very low benchmark, right? It's the appearance of potential need for care and support that triggers that Care Act assessment. Similarly, for the Mental Capacity Act, when it comes to assessing capacity, if we've taken all practicable steps in the ways I've described, but we're still concerned about the person's capacity, that triggers the duty to assess. The judge in this case put it quite well. He says, I'm going to change the language slightly because I think there is a difference. So the assumption of capacity is important. It ensures proper respect for autonomy by requiring any decision as to a lack of capacity to be based on evidence. But the assumption, like any other, has limits. When there is good reason for cause for concern, so there's your threshold for an assessment. When there's good reason to be concerned or legitimate doubt about capacity to make the decision, the assumption cannot be used to avoid taking responsibility for assessing and determining capacity. To do that would be to fail to respect autonomy in a different way. Okay, so again, I mentioned that because all too often you have a potentially high risk scenario, and the person's not willing to engage. Well, if there's legitimate doubt about capacity or good reason to be concerned, then we do need to assess and determine. All right. It might be we've got to base that on the evidence we've got, which may be the sort of surrounding evidence, if you like, photographs of the property, neighbors, information, etc., etc. But still, we can't just sort of walk away and do absolutely nothing because we're just going to assume capacity despite having doubt about it. Okay, because you'll end up potentially in the coroner's court and they'll say, well, were you not concerned about their ability to make the decision? Yes. Well, did you assess it? No. Why not? Well, we relied on the assumption. Yeah, but you were concerned about it. Why didn't you assess? Yeah. The other thing to notice is the terminology, because again, I think this is important. Assessing and determining capacity. What does that mean? Well, assessing it is the process for gathering evidence. That might take time, right? It could take days or weeks to gather the evidence relevant to capacity. That's absolutely fine. Take as long as you need to gather the evidence. Okay, so assessing it is not just a conversation you have with the person through the letterbox at 11:32, right? The assessment of capacity is about gathering all the evidence that's relevant to the issue, and then determining capacity is the conclusion. Can they or can't they make the decision based upon the assessment? All right. I think all too often we feel under pressure to sort of work this out on the day of the visit. Well, that's not how the Mental Capacity Act works. Okay. You can assess someone's ability to make decisions over time. And so I've sort of asked this provocatively in the negative. You know, if you've got someone with a hoarded home at significant risk, can you justify a decision not to assess? Because there's a lot of evidence going back to 2014 when practitioners have not assessed capacity when they should have done. They tried to rely upon the assumption, but that assumption is just a starting point. Okay, you can't hide behind the assumption to avoid taking responsibility. And so what I've suggested there is the more serious the risks are, the more we should document those risks. Okay, so even if, because the other human right that's potentially at stake, of course, particularly in relation to fires or potential falls, is the right to life. Okay, so Article 2 of the European Convention, even if you assess capacity, and even if your conclusion, your determination is that they've got capacity to make their own decisions in this regard, make sure that that is all documented. It's just as important in any kind of safeguarding scenario to document capacity as it is to document incapacity. All right. So if the person is willing to talk to you, talk through the risks that have been discussed. If this is your view, evidence why you think the person is able and willing to comprehend the foreseeable consequences. Evidencing capacity is just as critical as evidencing incapacity, depending on what your determination is. So looking at the test in particular, I think lots of people get this wrong, and then it leads to either a safeguarding adult review or worse still, a coroner's inquest. And I can understand why people get this wrong because of the way the law is phrased, right? So whenever you're looking at someone's ability to make a decision, You've got the assumption, that's your starting point. You've got the principle of support. What steps could we take to help the person make the decision? You then get the third principle, which is about unwise decisions. The law says essentially a lack of wisdom doesn't automatically mean a lack of capacity, right? There's a duty to assess. And as I said, this is not a lifestyle choice. All right, by definition, this is not an unwise lifestyle choice that we're talking about. So when you get into the world of assessing capacity, the law is crystal clear. The first issue is the so-called functional test, whether the person is able to make the decision. Now, I'm going to go through what the decision might be in a bit, right? But let's just carefully look at how the law is framed here. Because as I say, you might be dealing with a situation where the person, you know, educationally, intellectually seems perfectly able to make decisions generally in life. Now, the way the law is phrased, it's phrased in the negative. So it says you're unable to decide if you're unable to understand or retain or use or weigh or communicate the decision. It's phrased in the negative. Therefore, being able to make a decision means being able to understand the information and retain the information and use it and weigh it and communicate the decision, right? There are 5, not 4. There are 5 statutory abilities. And the reason I'm kind of stressing that is because in my experience of hoarding disorder, a person might be perfectly able to understand the foreseeable consequences, right? If I don't deal with this, then that might happen. There might be a fire. They get that. They might also retain it. They might also be able to weigh that risk up. Weighing information means being able to see the different parts of the issue and how they relate to each other. So they might be able to weigh up, if I don't get rid of all this flammable, material, whether it's newspapers, magazines, whatever, then there could be a risk of fire. They might be able to weigh that up. But can they then use that information is the critical issue. Using information is very different to the others. Using information is about being able to apply your knowledge to the real decision in the real world. And often in tricky scenarios, that is the fundamental question that you might have to be focusing on as a capacity assessor. All right, so a quick hoarding example. Imagine that someone's in a hoarded home, high up on the clutter image rating scale, have hoarding disorder, and they may say, I know I need to deal with this, right? And you thought, well, we've got eligible needs here. We're going to offer, I don't know, a cleaning service, or we're going to offer someone to come round and help you go through your stuff to just try and mitigate risk. They might even say they're willing to engage with that. Okay, so they're open to the idea of this support that the local authority is offering. But on the day, in the real world, they might not let that person touch anything. That could well be evidence of an inability to use information, right? Because you've got a situation there where someone can essentially talk the talk. They might come across and present very well and convincingly, comprehensively, but when the decision actually needs to be made in the real world, they might be unable to use the information because of hoarding disorder. Okay, now some people might refer to executive dysfunction. You don't need to touch that with a barge pole, right? as an assessor of capacity, you've got to be criteria focused, laser focused on these 5 criteria. And so as part of your assessment and gathering of evidence, if someone is open to the idea of support, let's imagine, but in the real world won't let them actually touch anything because of the significant distress at the thought of parting with these belongings or items that they have this emotional attachment to, your focus might be on, well, are they able to use information or not? And if not, is it because of a mental impairment? Okay. And just like, the concept of mental impairment in the Care Act, don't need a formal diagnosis. Similarly, for the Mental Capacity Act, you don't need a formal diagnosis. You shouldn't wait 6 months for community mental health services and a psychiatrist to say, yeah, this is hoarding disorder, right? You know the definition. In mental capacity terms, do you reasonably believe that the person is unable to use information because of hoarding disorder? That's the sort of benchmark, that's the threshold that you are dealing with. Okay, does that make sense? So, as I say, there might be very clear-cut scenarios, but there could be more tricky scenarios where your focus from a capacity perspective could well be on the ability to use information in the real world, as opposed to just what they're saying. Can they walk the talk, or do you have this conflicting picture when you're looking at the evidence? And the ability to use information, I think, often gets overlooked because people think, well, it's use or weigh. No, it's not. It's being able to use and weigh. Okay, there are 2 different abilities required for making decisions. And it's not new. Like back in the 1990s, when this was the sort of embryo of the Mental Capacity Act, when Lady Hale was sort of starting to draft what became the Mental Capacity Act when she was at the Law Commission. She said there are cases where the person can understand information, but where the effects of a mental impairment prevent them from using it. She then, in red, goes on to talk about situations where decisions are unconnected to the information. The decision is divorced from their ability to understand. And then this is the key line, really, from the Law Commission: a decision based on an inability to act. So in the real world, dealing with the risks, a decision based on an inability to act on information as a result of hoarding disorder is not a decision made by someone with capacity. All right. And again, I'm sort of emphasizing this in the context of concern that I'm not convinced that incapacity to make these specific decisions is always being picked up by practitioners, in the same way as eligible needs are not always being picked up. All right. So if you're called upon to assess someone's ability to make a decision, bear in mind there's a fairly low benchmark before we need to conduct an assessment, right? So is there good reason for cause for concern or legitimate doubt? If so, assess. That can take time. That's the gathering of evidence. Determine, that's your conclusion. Can they or can't they decide? And then document it either way. All right. We need to think carefully about what is the matter that requires a decision. I'm going to expand on that in a second because that's hard. But it's important because that then sets out for you the information that's relevant. And flowing from that is the importance of conducting what I tend to call a 3-dimensional assessment of capacity. And all I mean by that is that if I'm assessing your ability to make a decision, I'm not going to just base that on what you tell me, right? That's one dimension. That's really important evidence, but it's only one source of evidence that I'm going to draw from. I also need to look at any evidence from those who know you. So maybe that's your GP, or it might be your neighbours, or it might be someone else, as well as any documentary evidence. Okay, so think of capacity assessments as sort of multi-dimensional. You can gather evidence from anywhere as long as it's relevant to the issue. Okay, we've got to be criteria focused. There are 5 criteria for making decisions, not 4. Our assessment must be evidence based. And as I say, please don't forget the ability to use information. It's one of those statutory abilities that people often forget. And it's not the same as executive dysfunction, right? Executive dysfunction is a sort of clinical concept. What we're talking about is a legal concept of capacity, but where they often interact is the ability to use. Okay, can the person walk the talk? So there's your 3 dimensions. Real world evidence, conversations with those who know the person, and then conversations with the person. Absolutely critical. And if you've got evidence of conflict or divorce or mismatch between what they're saying and what they're doing in the real world, that might be evidence of an inability to use information, right? It might not, right? But it might well be evidence of an inability to use. And then the critical issue in terms of can they or can't they use information will be this: how does the person explain the conflict? So, you're telling me that, you recognize that if we don't deal with this, then you might get evicted, right? If it's a landlord tenant case, or if we don't deal with this, there's a risk of falls, or there's a fire risk. Okay. We've been talking about that. This is how we might address it. We try to address that, try to provide this service, but you didn't answer the door, or you did answer the door, but you wouldn't let anyone touch anything. Why was that? Probe. Why? Right? The why question is so critical. Now, the answers they give to those sorts of why questions will give you a real good sense of, is this someone with capacity that is perfectly able to use information, but they are willing to take all these risks, they know what the risks are, and they're making unwise decisions? I suspect not, given the definition of hoarding disorder. Or is it a scenario where they're unable to use the information because of hoarding disorder? Okay, so let's have a look at what the decision is. And I think because we've been going for an hour, we will take a short break before I delve into that. All right, so let's just give our eyes a quick rest for 7 minutes, and I'll pick it up at 11:55. All right, folks, see you then. You ready? Or is it just me?
Yeah, I'm here.
Good to go? All right. We're on the final leg, 35 minutes on the decision, best interests, and a brief word about the High Court. All right. Good to go. Thank you to those who have turned it on. Others ready? Fully refreshed? All right. So what is the decision when it comes to the capacity issue? Because in practice, whether someone's able to make a decision depends on what that decision is. All right, because if it's a massive decision with a huge amount at stake, they might lack it. But if it's a really simple, straightforward decision, they might have it. So how you identify the decision can have a bearing on the outcome of your capacity assessment, because it depends what's at stake. So are we looking at, the person's ability to make decisions about their property and financial affairs? Is it about their care and support that's being offered under the Care Act? Is it about their items and belongings? Is it about their tenancy? What is the decision that we are looking at the person's ability to make? So I'm going to go through some examples. As with all areas of law, everything depends on the particular context. All right. So in some scenarios, it might be one type of decision. In other scenarios, it could be a different decision. These are examples and worth bearing in mind when you're trying to work out what decision is at stake. So this is the ACGC case that I did 4 years ago now. God, this was the first reported hoarding case in the Court of Protection. So we set the precedent, and in essence, it was a fascinating case. You've got mum and son. Mum was in her late 80s, early 90s, living at home with her son. She had dementia and hoarding disorder. He had OCD and hoarding disorder. And this was the case where, I don't think we put this in the judgment, but I think it was this case. It might be another, but I think it was this one, where the social worker described them as living in like a Victorian slum. It was pretty extreme. And, you know, we're talking about hoarded items and belongings. We're talking about rotten food. We're talking about feces, urine in buckets, mice, the full works, right? Now, mum owned the property. Son was her primary carer. Mum tended to spend all her time in bed, really. So if you were to look at the judgment picks up a particular point in time. Like this case actually went on for quite some time before we reached the stage where the court had to make a massive decision. So just in terms of the background, for the first, I can't remember now, I think it was like first 6 to 12 months, the local authority initially wanted to get an order to remove mum to a care home. And I was acting for mum in this case, and we resisted that because we wanted to look and explore less restrictive options first. So for about 12 months or so, I think it was, we were mainly supporting, or the court was supporting the son to mitigate risk, and various services were being offered that enabled them both to remain at home, but in safer circumstances. But one night, her son went out, didn't come back as expected. She panicked. She phoned the police, who phoned the ambulance, because this was a property that was marked as a vulnerable adult property. So the paramedics turn up and they walk in. They probably thought, Christ, what kind of state is this poor elderly woman living in? They strapped her to a stretcher, carted her off to hospital, right? On reflection, I think that's probably a disproportionate response. Had the paramedics been fully aware of what was going on, it would have been far better to just phone the son to see when he'd be back. Do you know what I mean? But anyway, it was a proper kind of paramedic kidnap. And to be fair, I suppose sometimes we criticize paramedics for not taking people to hospital, but this is a situation where they definitely did. So she went to hospital, didn't really need to be there. Within a matter of days, she was discharged to a care home, and the deprivation of liberty safeguards were provided. So that's the sort of point in the judgment where the story is picked up, because there was no dispute about the mother's ability to make decisions in this regard. She lacked capacity to make decisions about where she lived, her care, her property and financial affairs. And so one thing the court did, because the son had LPA, lasting power of attorney for property and affairs, so the son gave that up, and we had a financial deputy appointed for mum. But the interesting bit about the case, so there are lots of interesting bits about this case. So one is the kind of classic dilemma, which is whether it was in mother's best interest to remain in the care home for the rest of her life in reality, or to have a trial period at home. And, you know, You'll see a lot of reference to a lot of the interesting principles. What's the point in making someone safe if it merely makes them miserable and all that jazz? And the court decided that it was in her best interest to have a trial period at home. But the really interesting and perhaps the most relevant bit of this case is about the son, because he had his own court of protection case. All right. So this is where we broke some kind of legal ground, really, because the son, as I say, he had OCD and hoarding disorder, and he was perfectly able to make lots of other decisions in life. But we focused in on his ability to make decisions about his items and belongings. Okay, so that's interesting because sometimes in hoarded home scenarios, where the person might be able to make all the other decisions, you might need to be pretty specific about the decision. Okay, so AC and GC, on the facts in this particular context, focused in on whether the son was able to make his own decisions about the items and belongings that he was accumulating. All right. And some guidance was given, because once you've worked out the decision, you need to then work out what information is relevant. You know, if you're assessing the ability of someone with hoarding disorder that we reasonably believe they have to make decisions about what's being hoarded in the property, what's required, you know, what information is relevant to that decision. So this case gives you a bit of guidance, right? Don't feel as though this is like gospel, because everything depends on the person and the issues and risks that they are facing, right? So you might want to add to this list, you might want to delete from it. It's not sort of legal gospel, but it is an example to help you. So in this case, there were 5 critical things, 5 key bits of information at stake when assessing the son's ability to make decisions about what was being hoarded. So firstly, the volume of belongings and the impact it was having on the use of rooms. Okay, now I won't go through this in detail. You've got the slides, but this is looking at the degree of belongings, the volume of them, and the extent to which they're impacting or impairing the usual function of the important rooms. Okay, so not the box rooms, but places like the living room, the kitchen, bedroom, bathroom. Second, to what extent does the person comprehend whether they're able or not to safely access and use those living areas? To what extent do they grasp the actual or potential hazards in terms of health and safety of those residing in the property? And again, it all depends on what we're talking about, right? What's being hoarded, but there could be all sorts of potential hazards that this is leading towards. So it might be to do with heating, lighting, washing facilities, use of the toilet, food storage and preparation, the potential for, you know, mice or rats, the risk of fire, one of the most common risks in my experience. You know, to what extent would they be able to escape if there was a risk of fire? So you would be looking at the person's ability to comprehend those risks, those hazards. In some scenarios, the level of hoarding might be threatening the structural integrity of the building, right? So if they've hoarded a lot of stuff in the attic, for example, and the ceiling is bowing, right? You might be looking at their ability to grasp that there is a risk here to the structural integrity of the building. That would be a pretty extreme hoarding case, but that might be relevant. And then the 5th one, which is quite often the major one, is to what extent does the person comprehend that safe and effective removal or disposal of hazardous levels of possessions is possible, Not everything. As I say, the aim of the game is not to like blitz the place and clear the house. It's about removing or dealing with the hazardous stuff to mitigate the risk. Okay, so it's interesting how, and I have to say, I will take all credit for this case because this was my idea. No, sorry. This is an interesting one because I felt it was appropriate to be very decision specific for the son, right? And so we had a fabulous expert, Professor Paul I can never pronounce his surname, Psychowskis, I think. If you Google him, he's a professor of hoarding in Oxford University. He was our expert in this case, and he was instrumental in helping us work out, okay, for this decision, what do we think the information is that's relevant? Okay, so you need to establish this and explain this to the person because this is the backbone of your assessment. Can the person understand all of that, retain all of that, use all of that, weigh it, right? In particular, use it in the real world. Don't forget the ability to use. Okay, so in this case, for that decision, the court decided that information was relevant, and it was found that based on the evidence, the son was unable to make that decision. In some other scenarios, your focus might be on the care and support side of things. So you've assessed that they have eligible needs, you're offering or trying to arrange a service to meet those eligible needs. Again, go back to the definition of an eligible need. It's where the person requires care and support to prevent a significant impact on their well-being, right? That's an eligible need. So if you're assessing my capacity to make decisions in relation to my care and support, whether or not to have the support that's being offered, the LBX case is quite helpful in terms of information that's relevant. And usually there are four key things. So what areas do I need support with? What sort of support? How often? For how long? Who will be providing it? And then again, often crucially, what would happen without it or if I refused it? What are the reasonably foreseeable consequences of not having whatever the support is, whether it's a cleaning service or, a sort of hoarding specialist from the landlord, or whatever the service is, whatever care and support is being offered. Am I able to understand, retain, use, and weigh the foreseeable consequences of refusing that? Okay, so the first scenario focuses on the decision relating to items and belongings. This one focuses on the decision relating to care and support. And then in this scenario, this is the second hoarding case, right? There are two main hoarding cases, ACGC and then this one. In this case, the court decided actually, rather than being so specific with the decision, I, the judge, am going to take a more holistic approach because everything is kind of interlinked. You can't separate that decision from this one. So I'll tell you more about this case when we look at what happened in her best interest. But in terms of the decision, the judge says, well, it's all interlinked. So there's a sort of tenancy issue, there's a care and support issue, and there's an items and belongings issue. It's one big decision. Okay, and as I mentioned earlier, the bigger the decision is, the harder it is to make. All right, so in this case, the judge looked at one big decision relating to obligations under the tenancy, the care and support stuff, and the ACGC stuff. And again, when that information was required to make this big decision, X was found to lack capacity to make it. Okay, so everything depends on the context of what you're dealing with, right? It might be you're focusing on a very specific issue relating to the hoarded stuff. Can they make that decision? Including actually following through and acting on the information that's relevant, being able to use it. In other scenarios, it might be about care and support. And then in other scenarios, it might be a bit of everything, because everything is so interlinked, and it would be artificial, or what judges have said, incompatible, to sort of silo the different decisions into separate compartments, right? So this sometimes requires a bit of thought, and obviously how you identify the decision at stake could well have an impact on the outcome of your capacity assessment. Okay, so that's some guidance on assessing capacity. If the person lacks capacity, then what? You know, what does the Mental Capacity Act actually authorize or allow us to do in the name of best interests? Again, this is pretty interesting, because you cannot, for example, make property and financial affair decisions unless you've got legal authority to do so. And the legal authority to make financial decisions or property decisions is either a property and affairs lasting power of attorney or a financial deputyship. All right. So without one of those, we have no legal authority. Obviously, as someone I think mentioned in the chat, there are other potential things in terms of like charging orders or whatever. But in terms of having the legal authority to make financial decisions from someone, unless there's a financial LPA in the person's life that's been appointed, or unless we have financial deputyship, we won't have the legal authority to make financial decisions. What the Mental Capacity Act does provide is Section 5. So Section 5 gives us a defence to liability when we are doing acts in connection with care or treatment. Okay, so we can act in someone, let's imagine you've got someone who lacks capacity to make decisions about their items and belongings. The question is, what can we then do in their best interests? Well, we can do things that are in connection with care or treatment. And I've given some examples here of what I think you can do in the name of best interests. So, for example, a care worker removing rotten food from the person's kitchen as part of a care visit, clearing a pathway through the stuff that's been hoarded to enable safe access for carers. Again, I think that would be covered by the Mental Capacity Act. Removing items that create an immediate health hazard, blocking, you know, fire exits that are being blocked, etc. I think that would be something in connection with care. Cleaning a bathroom sufficiently for the person to be able to wash. Again, that's connected with the issue of care. So I think that could be done in the name of best interests. But for other stuff, we might need the Court of Protection. So in AC and GC, the courts authorised the local authority to enter the property and dispose of belongings. And in the X case, the court authorised the person to be removed from the property and for work to be undertaken. I'll go through those in a bit more detail in a second. And the other thing we might need to think about, if the person lacks capacity to make a decision, is whether they need a financial deputy. Okay, so just before I get on to the Court of Protection, let me just flag up a few things worth bearing in mind before we go down the Court of Protection route. So the court would ordinarily expect, if it is the local authority, for example, to be bringing this case, it would ordinarily expect an explanation as to what else has been tried first. Okay, so I was talking about the other legal frameworks, the importance of working together, different agencies, what steps have already been tried, and what was the person's response. Second, evidence of current risk. Okay, so a risk assessment. Third, of course, evidence of incapacity for this particular decision. Now, it's worth noting that to get the door open to the cord of protection is quite a low threshold, right? In the real world, I would have to prove that it's more likely than not that you can't make this decision, right? But to get the court door open, the threshold is lower. I would only have to show that there's reason to believe. So that's a lower evidential threshold. Have I got evidence to show that there's just reason to believe that you can't make this decision rather than the higher threshold of more likely than not? Okay. And I'm stressing that because remember the case I was talking about where lady in her 60s, totally unknown to services, wouldn't speak to us. All we've got are photographs of the outside of the property and through the letterbox, and some evidence from the neighbours. Right? We've got nothing from her. She won't speak to us at all. Could we make a court of protection application based on that evidence? Well, there's not a lot of evidence there, but do these photos and the sort of neighborhood intel provide a reason to believe that she can't make decisions in this regard? Arguably, yes. Do you know what I mean? The threshold is lower to get the door open to the court of protection. Then, of course, once you're in, the court can make orders. So reason to believe is the threshold for the court of protection. You'll see that in section 48 of the Mental Capacity Act if you want to have a look. So we need some evidence of incapacity, a best interest plan. One thing so I've created, because you can get away with all sorts of things in the court protection. I've done loads of hoarding cases when I've thought it appropriate to use all sorts of different approaches. So I've had hoarding support plans. I've said to a social worker, please can you create a hoarding support plan, which essentially sets out the plan in terms of dealing with the stuff and the risk, but also the support to follow, because this is going to cause typically emotional distress. So what's our plan to support the person emotionally if we are looking to remove stuff and perhaps recycling it or storing it somewhere else, right? Because again, you need to think practically. So sometimes rather than binning stuff, we might be looking at purchasing something to put in the garden and storing the stuff in there, at least temporarily. So, you know, what's the plan in terms of addressing the emotional fallout from this best interest decision? In other cases, I've designed an achievement plan for the person. So setting them small achievement steps, right? Because again, this is going to take time, right? There might be certain things we need to do urgently. So if they've got no heating or electricity and they're using candles, as I mentioned earlier, the fire service are brilliant at really practical suggestions, right? So they said, look, they don't need, you know, live flames. Get them battery candles or some other form of lighting, but usually battery is what we're talking about if they don't have any electricity. So get them battery lighting, or, you know, fire blankets and all that jazz. Like the fire service are great when it comes to mitigating fire risks. One of the most helpful agencies I've found in hoarding cases. So yeah, I've set achievement plans where, you know, we literally give the person the clutter image rating scale. It's like at the moment you're on an 8, right? Your aim this month is to get down to a 7. Yeah, and then they can see it, and they you know, you might be able to support them to engage in that. It's tiny achievement steps that we're working towards. So some kind of plan on a best interest basis. The other thing just to be mindful of is money. So if you're in a care home with dolls, like in ACGC, if there's a dolls authorization, you'll get a free lawyer regardless of your finances, right? But if you're still at home, then you don't automatically get a free lawyer. right? Because legal aid is means tested. It depends on your financial means. And I've just set out there the pretty low thresholds. So someone would have to have less than that income, less than that disposable income, so gross disposable, and less than that capital in order to qualify for legal aid. So I mentioned that because in some of these cases, the person may end up paying for their own legal representation. All right. But if the risks are that high, then that may well be required. I've mentioned financial deputyship. So what do we do in ACGC? Well, we appointed a financial deputy for mum, which was great because they basically led on the intervention side of things. The court decided that it was in mum's best interest to go home from residential care and in the son's best interests to have support with house clearing and cleaning services and to make the property safe. So this is just a quick example of the sorts of orders that the Court of Protection can make. It's lawful and in the person's best interest for any house clearing company or cleaning company or any other support service instructed by the deputy, if there is one, to gain access. So the court can give access to the property. And in short, there may or may not be a deputy, but either way, the court can give us the legal authority to go through the stuff and dispose of whatever needs disposing of or put into storage, whatever the plan is. Okay, because that's not covered by Section 5. That's not something necessarily we can do without the court involvement, but the court can essentially give us the legal authority to do anything that's in the person's best interests. Okay, so that's what we did in that case, and it was a great outcome. We managed to enable them to remain at home, but also deal with risk. In the other case, the X case, this is on the facts, pretty extreme. She'd be living in a rented maisonette for 27 years. The court case had been going on for 2 years. Everything had been tried, all right, but the risks were still massively high. So massive fire risk, level 8, 9 on the clutter image rating scale, risk of falling, etc., etc. Multi-agency response tried already. So environmental health had served notices under some of those other legal frameworks I talked about. They'd even had warrants to enter the property, but she was threatening self-harm if anyone tried to enter. Mental health had also been involved. They'd also tried to involve a specialist hoarding therapy service. So notice multi-agency, tried all other things, but essentially she wouldn't engage, and she was, there's a risk to life. There's a risk that she might take her own life if this was forced. So as a last resort, having exhausted all less restrictive options, the court really only had one option remaining and decided it was in her best interest to be removed from the property, if need be, with restraint as a last resort, and deprived of liberty in a supported living placement for a limited period of time to enable the necessary clearance to take place, with a plan to return her once that work had been undertaken. Okay, so, essentially, when all else fails and the risks are still massively high, the Court of Protection, as a very last resort, can order the person's removal. All right, so those are all the key important things that I wanted to cover. And the final thing is just very briefly on the inherent jurisdiction of the High Court, right? I think in practice it's going to be quite unusual for you to go down this route. I think ordinarily you would try the other legal frameworks, perhaps approach the Court of Protection. So I don't think you're really going to need the High Court, but this might be relevant if, for example, I suppose you've got a vulnerable adult living with someone who's hoarding, right? So that's Mr. Myers. And this is more of it's more of a neglect case. It's not a hoarding case, but just be aware of the High Court. So this is a bit of law that's sort of out there. It's only available to High Court judges, right? So you and I can't use this like we can the Mental Capacity Act. This is an area of law that's only available to High Court judges. And in essence, it's available when you've got a vulnerable adult. That's the definition of a vulnerable adult. And it's targeted at adults whose ability to make decisions has been compromised, not by hoarding disorder or some other mental impairment, but by something else, such as coercion or undue influence. All right. And the reason I'm suggesting this is going to be unusual is because in the court of protection, a best interest decision is made on behalf of the person that can't decide. And sometimes, as we've just seen, it's coercive. The court has just removed someone with restraint as a last resort, right? The best interest decisions or orders are on behalf of the person and can potentially be quite dictatorial, to use the term. Whereas the High Court is different. The High Court, rather than being dictatorial, is more facilitative. So you don't get the orders against the vulnerable person, right? The orders tend to be against someone else, the person that's exercising undue influence or constraint or coercion. So that's why it's not normally required in a hoarding case. But just to give you an example, Mr. Myers was 97. He had diabetes, osteoarthritis. He was blind in both eyes. He was living in squalor with his son. And there was a whole history behind it. But jumping forwards, when social worker eventually was allowed to go in, she found that they were again living in squalor. He was partially clothed. He hadn't eaten or drunk anything for days. There was feces on the floor. He didn't have a mattress. He was sleeping on the slats of the bed. And at that point, he had a UTI, and in his best interests, was taken to a care home. But within days, the UTI cleared up, and then he wanted to go home. At that point, there was no mental impairment, right? Just diabetes, osteoarthritis, and blindness. So it was a tricky scenario. And sorry, I've repeated the facts there twice, forgive me. So looking at the second paragraph at the bottom, the High Court judge made an interim order, right? So he was a vulnerable adult whose ability to make decisions was impaired by the influence of his son. Okay, so he had no mental impairment or disorder, but his decision making was being impaired by the undue influence of his son. So therefore, the High Court judge said, right, well, you can't go home unless your son moves out. All right, so notice the order was against the son. And the court said that the treatment of Mr. Myers was not merely neglectful, but it was abusive and corrosive of his dignity. All right, and even though the court order preventing him from going home was interfering with his autonomy to make decisions, it was to preserve his dignity. Again, I was talking about the balance between autonomy and dignity this morning. So that's a sort of neglect scenario, I suppose, that emphasizes that when all else fails, you might have a vulnerable adult whose decision making is being affected by an external factor. You might, in extreme cases, need to get legal advice about the High Court. All right, so we've covered how hoarding disorder is not a lifestyle choice. Multi-agency response is critical. It can amount to a mental impairment without a formal diagnosis under both the Care Act and the Mental Capacity Act, and can amount to a disability for reasonable adjustment purposes. It could give rise to eligible needs, but what have we got to meet those needs? Autonomy is obviously fundamental, but sometimes needs to be balanced with dignity. Trust is critical. Don't forget the ability to use information, and we might need to think about the court of protection if we need access, or if the person's unwilling to accept support in order to manage the risk. And in some scenarios, we might need to think about a financial deputy if the person lacks the ability to make that decision. All right, so it's a fascinating challenge, not just to the person who often for decades has been struggling with it, but also from the state's perspective, because it's one of those scenarios that impacts on lots of different organizations and agencies. Bring in that expertise of each. And if you're looking at the Mental Capacity Act, don't forget the ability to use information. All right, so any final questions before we finish? Deborah's jumping off to another meeting. Thank you, Kimberly. Any questions at all? I've re-put in the chat the link to the materials. All right, well, I hope you enjoyed that. I'll stay on the line for a few minutes in case anyone wants to ask me anything, but the rest of you, have a lovely Friday, and I hope you found that helpful. All right, folks.
Thank you very much.
Thank you.
Take care.
Thank you.
Thank you. Thank you.
Thank you.
very much.
Thanks, Ina.